GOA is threatening to sue a New York sheriff over non-adherence to the Bruen decision. Let's go ahead and talk about it. What's up, everyone? How you doing? John Crump here. I want to make this video as quick as possible because I have a lot to do today and I'm short on time. If you could do me a favor, like, comment, and subscribe. You know the drill. You know everything that you need to do. Okay, so the Fulton County, New York Sheriff's Office put out a Facebook post saying that everyone's permit will remain the same, and until there's a process in place, that everyone's permit will remain restricted. The sheriff, Richard Giardino, who is also a lawyer, said that even though the Supreme Court ruled that the New York law is unconstitutional, it still needs to be remanded back down to the circuit court to review the case and issue a decision, and then that the circuit court can also remand the case back down to the district court, which isn't exactly how it works when the Supreme Court says something is unconstitutional. There is no need for the circuit court or the district court to rehear any type of case because the Supreme Court ruled that Bruen is unconstitutional, and therefore all laws surrounding Bruen are unconstitutional. The sheriff claims to be pro-gun, even though he does support NICS and does support mental health screenings for gun owners. He says he is pro-gun. GOA sent the sheriff a letter stating that he was wrong and explaining how he was wrong. GOA also points out that the sheriff could lose qualified immunity and be responsible for monetary damages against anyone that had their rights violated. There are multiple cases where officers have lost their qualified immunity when they violated a constitutional right that has been clearly established. In the Bruen case, the constitutional right to carry outside the home is clearly established, and there's no need for a court to rehear it before the order can take effect. The order is in effect the moment that the Supreme Court issues its judgment. The lawyer of record in the Young versus Hawaii case faxed over a demand letter stating that the sheriff had 5 days to comply with the Bruen decision before GOA launches a lawsuit. In the letter, Stambole highlights that states such as New Jersey are even complying with the Bruen decision. In response to the GOA demand letter, the sheriff made another Facebook post stating that anyone that wants the restricted carry license to be changed to an unrestricted carry license needs to contact the judge that issued the license and ask him to change it to an unrestricted license by referencing the Bruen case. He then linked to a Newsday story that said New York lawmakers are close to amending the concealed carry laws in the Empire State that the Supreme Court found unconstitutional. I talked to the sheriff directly. He states that he stands by his assertion that nothing changes and the order from the Supreme Court does not go into effect until the circuit court and the district court rule on the constitutionality of the New York law, which I talked to other lawyers and law professors, and they both said is 100% wrong, but he is sticking by his guns. So what happens now? He says that they are putting in a procedure, but he's not really sure how long that procedure is going to take to issue unrestricted carry license. But until the lower courts rule, he is not going to tell his citizens anything that he does not believe. I also asked him if he took an oath to the Constitution, which he got a little bit salty on and didn't answer me directly, but I think he knew where I was going on it. So what will happen next? If he doesn't change his tune, GOA will be filing a lawsuit and it will go to the courts and he can be held for monetary damages. All right, that is it. I hope you have a wonderful day. I got to get out of here. I got to go get my kid. So I love you very much, and I will see you later. All right. Bye.